I would. How do we put it on the slide so it goes?
Oh yeah, that
Yeah.
is.
Yeah. And would this work?
I think so. I never tried. Oh, you can try it.
Uh-oh. Okay. Don't press something, see if it comes up. We have actually got a stick.
Oh, okay. Here we are. It's just really slow.
So before Lee starts, welcome everybody to sunny Manchester. It's not raining. You can get the furthest away award from the south coast. Amazing. So thank you to the speakers. It'd be good if we all introduce ourselves because there's some new faces. So start with Gavin.
Well, Saturday. I'm Gavin Terry, self-employed consultant and CTSI lead officer for intellectual property. So I've come along to learn about Colin.
Okay, Colin's the last one. That's Melissa.
Colin the secretary, yeah. Well, we've got a few relatives, haven't we?
He's got Connie and he's got lots of competitors. Yeah.
Not as good as all. Thank you.
I'm Tom Morgan, so I'm a membership manager at CTSI. I've been in post about 5 months now, so thanks for being with me. I'm really interested to learn more about the profession. Get to know members.
I'm Wendy Fox.
It's like sharing when we're done.
I'm chair of business members group.
Okay, hi, I'm the coordinator for training standards and advice, but I'm also the CTSI lead officer for voting. And I'd ask if I come along and tell you a bit about that. That was Dr. Fire. I work for Attribute Global. I'm 17 years training standards, so member.
Pete Martin, training standards, working software. I'm currently doing a lot with Morrison's. It was gross.
I'm 7. I'm a self-employed consultant, mainly in the area of labelling. So that's really interesting.
I'm talking, I do work in consultancy and back in trading standards, I'm going to be doing your computer instruction on next week.
Hi everyone, Lewis Collentine. Day job is at TK Maxx of HomeSense, trying to keep them and our products in check, and also wear the hat of race and equalities working group chair.
Hi, I'm Ken Daly. I'm the Trade Standards National Coordinator in Scotland for the Heads of Service Group Scots. Probably flying for the furthest travel. So come down from Dundee on Sunday, so I've been here all week at the conference, so just thought I would concern myself. I'm also CTSI fellows.
I'm David Hetherington. I'm an associate member of the CTSI, and I'm a solicitor that specialised in, or has specialised over 35 years in relation to defending companies with regulatory breaches in respect of underage sales, use by dates, and crazy things like that.
I'm Melissa Blommer. I'm a training trademark attorney at HGF.
Hi everyone, I'm Emma. I work at HGF as well with Melissa and Lee.
And I'm Lee Curtis. I'm at HGF as well, and we're going to start the talk. So, should we start?
Yes, thank you, Lee. Thank
Yeah.
you.
So we're going to talk about some recent lookalike cases. There's been quite a few. When I did the slides, I got mine mixed up between Lidl and Aldi. I'm doing Lidl. They're Melissa and Emma are going to talk about Aldi's issues. And we're going to deal with the Thatcher's cider case on packaging, M&S gin, spec designs, which Emma's going to talk about. Melissa's going to finally end with Colin the Caterpillar. So I'm going to make a way. You probably pick up from my accent. I'm from Somerset, so it's probably so I'm going to do the Thatcher's one. That's actually Tor Hill, which was made to run a few times at school. So Thatcher's obviously a Somerset cider maker, so it's a bit close to home for me. And just to explain what actually happened in this case, it was between Thatcher's cider and Lidl, and it centered around lemon cider and packaging. Thatcher's product is on the right side, and ultimately they were actually unsuccessful in trademark infringement and passing off claim against Lidl, who were producing the Taurus cloudy lemon product both in the yellow. Thatcher's actually did have a trademark registration for the packaging, which is, I think, a lot of retailers and a lot of producers actually forget about registering the packaging. They concentrate on the brands. And also the judge actually accepted that consumers did actually make a link between the products in the minds of the public. I think the overall consensus amongst lawyers and trademark attorneys is Thatcher's were a bit unlucky in this case, but it also shows some of the weaknesses of when you have a lot of the similarities are like product category similarities, the yellow, which everyone was using for lemons. There's a big argument about whole lemons, half lemons in the case. And also there seemed to be an issue with the pleadings at the start by Thatcher's. So, as I said, there's a possible issue. There was some criticism of Thatcher's pleadings by the judge. And the case actually only proceeded on the basis of a single can of Thatcher's Cloudy Lemon against the 4-pack of Aldi. So there was already a difference in the pleadings, because I think Thatcher's were a bit unclear right at the start about actually what they were claiming as the distinctive elements of their product. Also, as I said, Thatcher's had a registration for the packaging, which is good, but it was only for a 2D label, not the whole 3D look. And although the judge found some similarity between the brands, she actually found that it was relatively low similarity. And just to explain what the claim was, Thatcher's claim was really on 3 grounds. One, the packaging was similar and people would be confused. They also claimed that their brand and packaging had repute, and in that case you don't have to prove confusion, you just have to prove that the other party was like free riding or causing detriment. And then the third claim was passing off. So in the first claim on confusion, although some similarity was found, it was found to be low, and that's where that claim failed, because she just held the packaging wasn't similar enough, mainly because the similarities were maybe slightly generic. Lemons, yellow for a lemon cloudy cider and things like this. They were actually a bit more successful on the reputation claim. It was held by the judge that Thatcher's had a reputation. It was quite a successful product in that category. She also found that the consumer actually made a link between the 2 sets of packaging. So when you go into the store, consumers would think, oh, is that something to do with Thatcher's? And that's the first hurdle you have to overcome on a repute claim. But what she actually held in the end and actually dismissed the reputation claim was she didn't think Aldi were free riding, Lidl were free riding on Thatcher's repute. I think mainly because this line of cider is actually a whole range for Lidl, so they have all different flavors, and lemon was one of them, and she seemed to center on the fact that Lidl's sales for their cloudy lemon wasn't particularly out of line with the others. There wasn't a big jump because of trading off of Thatcher's reputation. A lot of people think that was unfair, but that's why the repute claim failed in the end. So basically, she said they weren't trading off their repute.
Have you done, some consumer research?
Yeah, I think people accepted that it was a benchmark. Lidl accepted they were benchmarking, but she very much centered on the sales figures, that there wasn't any major uplift in Lidl's sales because of so the cider one wasn't, I don't know what flavors they have. Cider one wasn't out of, I don't know if you get blueberry cider, I don't know. It wasn't out of line with the other flavors, if you get my drift. So she sort of said they weren't making any basis. The other thing is surveys tend to be very hard to get in a court action. There's very strict rules on what you can and cannot say and what you can and cannot, obviously not leading questions, finding granny outside of Asda and getting her confused. That isn't a basis of a good survey. Some surveys get in, but generally it's the judges often say it's my decision to make a valid thing. And as I said, on the passing off, it was accepted by both parties that benchmarking was a standard practice in the industry, which it is. You go into the average supermarket, all the major supermarkets benchmark off the brand leader. Lidl's argument was they weren't benchmarking off the Thatcher's brand, they were benchmarking off the quality. So they were tasting it, and actually at the hearing, they passed around lots of cider and had a taste test and insisted the judge tastes it. So they were saying we were doing as good a quality as Thatcher's, but at a cheaper price. That's what they were doing. A major why the passing off claim failed also is with passing off, as you probably know, you have to take into account everything. And obviously Thatcher's and Taurus, the two word marks, they sound quite different. So that was a way of differentiating. Also, I think another, and Melissa's probably going to talk about this with Colin, is you go into a Lidl, you don't expect maybe necessarily that Thatcher's is there. So that's a distinguisher. And also the common elements weren't just enough. I think there was an argument over half lemons and lemons, the stylization of cloudy lemon. I think lawyers spent a lot of money on that. So this was another distinguisher. So just a few takeaways from the Thatcher's case. I think if Thatcher's had made maybe better pleadings at the start, it would have helped them. So concentrating on the 4-pack rather than the single brand. Also consider 3D trademark registrations. You might think a 3D registration for the whole, that's obviously the Lidl brand, but for the whole tin is quite hard to get. But if you have the actual branding on the side, it's relatively easy to get a registration for a 3D thing. So that's sort of bringing in everything in your trademark registration, and passing off generally is much harder to pursue. So if you can get a trademark registration 3D, that would be good. I think everyone thought the Thatchers were a bit unfairly done by in the end, and they were a bit unlucky. So the judge said that people would make the link between the packaging, but then didn't go to the next step of saying you had a big uptake in sales. And then finally, it just shows the difficulty with passing off actions, that you have to take into account everything. I think in most product categories, there is a common theme through all these products. Certain products, obviously lemon has a yellow look, and I just think that's the difficulty. I think the British brands, people are still trying to say that they need extra laws to stop this parasitic branding by supermarkets, and Aldi and Lidl are particularly bad or good at it. So there's still a consternation. I don't think any extra laws are going to be brought in, just because, yeah, I'm a trademark attorney, but I just think it'd be too restrictive. You have to accept that supermarkets are going to compete. So that's the Thatchers, and then we'll move.
How much cider did the judge drink by the time?
I don't know.
That was the goal.
No, so I should, so. I was telling Emma and Melissa in the village I was brought up, they had just after all 23 cider houses and 4 pubs. There's only 1 pub left now, so. So yeah, but I think Thatchers are still doing very well. Their adverts are on the telly a lot, so. And they haven't, to the best of my knowledge, they haven't appealed. So,
Redesigning apparently,
sorry,
that was a redesigning apparently.
maybe. That's another way, maybe, that you redesign, get all your trademark registrations in a row and go from that.
Designs as well.
And Emma's going to talk about M&S, which is designs. I'm happy to control the slide.
Okay, sure, thank you. Yeah, so this was a slightly different case, quite recent, well known. M&S's light up gin bottles, which you might see around Christmas time. And they took action against Aldi's quite similar gin bottle packaging design on the right. And that's M&S on the left. In contrast to the previous case, this was about registered designs. So when it was looking at whether they were similar, we were only looking at the similarity of the actual products themselves, not the names, which was quite helpful. If you do register a design, it just protects the look of the product, which is, it gives you quite broad rights compared to the Thatcher's case. So here, M&S was successful, Aldi appealed and then again lost. They had registered designs for their bottle on the left, which we'll come on to on the next slide. But essentially the design showed a light gin bottle with these gold flakes swirling around inside. And that's what they relied on. It does highlight the importance of, firstly, just design rights in the first place for protecting product design and packaging, as well as say a trademark for the brand name. And then passing off comes in when there's no registered rights, I suppose, but that protects the overall get-up. And then also the importance of clear design drawings. So when filing a design application, making sure that they're broad, not too specific, so it catches more instances of this kind of copycat use, and that they're clear as well. Can we go on to the next slide? So yeah, just to show that point a bit more, this is what M&S had registered. So these are all 4 separate designs. So there's really no limit on the amount of designs you can file. It's a good idea to have a few different variations in there. So here they had the gold version, and that's been shaken up, so the gold flakes can be seen floating around, so you get an idea of what the product is through its, I suppose, how it looks to consumers. And then they had these 2 designs, again, still unshaken up, and had used a dark background to highlight the inside decoration. But they essentially were able to rely on all of these against Aldi's product. And they did use a product description to show that it was a light up gin bottle. So usually this doesn't form part of the design, it's just an additional indication, more of an admin requirement than anything. But here, it was quite important in the sense that the judge said we can look to that to determine what the designs actually show, and then how that compares to the competitive product. So without that description, it might not have been that clear that this was a light up bottle, which was quite key. They might have just thought it was gold. So it helped inform the interpretation of the designs that M&S were relying on.
I think with design, the judge has to look at what you got registered, and then what the other people, and he or she has to immediately know what the design is. But as Emma said, he took into account that it was a light up gin bottle.
Yeah.
There was also an argument, wasn't there, Emma, about the black background. The other side tried to argue it wasn't a clear bottle because it had a black background, but that was shut down. So
yeah, and they did also have without the background. But yeah, they wouldn't look at what M&S were actually selling, they'd look at what exactly was shown in the design registrations, which is why compared to passing off, it's a bit more important to think about what that showcases. And then the test for design infringement, registered design infringement, is whether the competitive design produces a similar overall impression compared to the registered design. So here they felt that Aldi's design did, and ignoring the name, they have a similar cork top and design inside. So they did play, like, notwithstanding the interior design and the gold flakes, I think they were flying quite close to M&S's product overall. Because IP rights can't protect a general idea, it has to be quite, a specific version of that. But here, there's lots of different ways, lots of different shapes you can have a bottle in. that would differentiate a bit more. But yeah, they were quite similar. But it's a good example, compared to Liam listed examples of where a retailer's been successful. And highlights registered designs to do that. Oh, and this was after the Colin Caterpillar, so we're not in chronological order, but the social media team obviously jumped straight on that, which has been one of the funniest things to come out of the dispute.
This is going to talk about the PR battle between Aldi and M&S as well. So yeah, 25 years, and they're renewable every 5 years. You have to file your design within with self-disclosure, so you can launch the product and then you've got a year to file your design application. That's called the grace period, but you have to do it within that first year, because if you file after that grace period, some countries don't have a grace period, China doesn't, but most countries do, it's usually a year, it's invalid. And just to give you an example where it goes horrendously wrong, Rihanna, when she signed her contract with Puma, she was the creative director. She wore some shoes, some trainers, and they took photos, put it on Instagram, 300,000 likes. Puma delayed filing the design application to 2 years after. And a Dutch retailer got it cancelled because it was outside the grace period, completely destroyed the design protection for one of Puma's major trainer lines. So if you're thinking about design registration, either do it before launch or you make sure you do it within the year. But it's 25 years and renewed, and it's relatively cheap. It's often referred to as like Cinderella bit of IP. We do a lot of designs now, but just think about it. You don't go through an examination, it just gets granted.
It's a few weeks, isn't it?
A few weeks, yeah. With a EU one, I've had it, bought it in the morning and it got granted in the afternoon. So
designs have to be completely new as well, which is
yeah.
why if that just redesigned, they'd be able to then register essentially the design of its packaging and get protection for that. But its existing packaging would now be outside of that grace period.
And if you think about a lot of big football clubs, they redesigned all their logos. That wasn't out of the goodness of their heart. A lot of it was because they were just registering new designs, so they can get design registration, trademark registration, copyright, passing off rights. So, and that's maybe why Thatcher's are moving towards that new design. So they're gonna get it, not say do it properly now. I think they did quite a good job, but maybe better. And then if Aldi or Lidl did move towards them, they can catch them. So
just on that 1 year grace period, presumably the German discounters will act quite quickly if they see a product that's doing well in the market. So I'm guessing we can make sure that although you have that 1 year grace period, you get your registration in before a German discounter then.
But the self-disclosure. So if we had this with a colleague, we act for Steve Madden, who, with all respect, they get inspired by designers. And we thought, oh, if the brand designer hadn't filed their design application, like you said, and we knew about it already, could we immediately invalidate their registration? But because our knowledge is based on their disclosure, it falls within that grace period. I would say the Rihanna case, to me, shows you probably should file it before you disclose, but you do have that 1 year grace. The big problem is China, because there's no grace period there. And if you disclose really anywhere in the world, that's global disclosure, and you completely destroy your Chinese design registrations. And given that most products, maybe not food products, but a lot of products are made in China, that's something to think about. So, okay. So Melissa's going to talk about Colin, which I think all of you came to see.
M&S started selling Colin the Caterpillar cake about 30 years ago. And since then, the brand has grown. There have been several brand extensions. So you have the Connie the Caterpillar, and then also you have partnerships with other brands like Macmillan and celebrities as well. And since M&S brought their product out, other retailers have brought out similar products, which you can see on the right side of the screen, and M&S's product is on the left side of the screen. So in April 2021, M&S sued Aldi for their the Caterpillar product. And they had two bases to their legal claim. So the first base was passing off. So M&S said that they had goodwill in their packaging, in the appearance of their product, and also in the word marks. And they said that Aldi's sale of a similar product would misrepresent to consumers that there was a link between Aldi's product and M&S's product, and this would damage M&S's goodwill. And then the second base for their claim was trademark infringement. So I think on the next slide, you can see Aldi had, on the slide, sorry, the slide.
Oh.
You can see Aldi had some registrations for word marks like Colin the Caterpillar and Colin the Caterpillar, and also for their packaging. And this just was used against Aldi's use. They said that Aldi's use of similar marks would confuse consumers and would also damage M&S's reputation as well. So that was the second base of their legal claim. And the case eventually did settle. So in February 2022, Aldi did agree to make some changes to their product, which you can see here. They made some changes to the eyes and the mouth of the product, which M&S said they were happy with.
We would say very subtle changes, won't we, Marissa?
Yeah, exactly. But yeah, the case did settle. And there were some PR implications to the legal, to the M&S bringing the legal claim. So Aldi began bringing out a campaign, kind of mocking the dispute. So they had memes and hashtags like Free Cuthbert. And what that did is that just downplayed M&S's concerns. And it also brought attention to the fact that there are different products on the market. There are different Caterpillar cakes. So consumers were more aware of that. And even though the case did settle outside of court, there are arguments for and against M&S actually having a claim against Aldi in the first place. So because there are so many Caterpillar cakes on the market, you could say that the Caterpillar mark isn't actually distinctive in relation to cakes. And the use of the Caterpillar mark in relation to cakes is also generic. So why should M&S have a monopoly with that? And you could say that consumers will know that the cakes are being sold by different retailers. So there's less chance of a likelihood of confusion or a misrepresentation. So that's a major argument against M&S, and also the fact that there are so many different cakes on the market suggests that, or it raises the question, why did M&S bring a claim against Aldi in the first place? So some people say that this is because Aldi was taking a bigger market share for M&S. And another argument is that the Aldi cake was actually more similar than pancakes, or the Aldi was a discount and M&S wanted to stop the matter getting out of hand. You could also argue that they are sold in different trade channels. So M&S cake is sold in M&S, the Aldi cake is sold in Aldi. So you would know when you're buying the M&S cake that you're buying it from M&S, and when you're buying the Aldi cake, you're buying it from Aldi. So and then also the PR issues also brought attention to the fact that there are actually similar products on the market. So which consumers really be confused. But overall, I thought that M&S maybe had a claim because there are issues of reverse passing off and post-sale confusion. So once the product actually is presented, it's usually presented outside of its packaging. So at an event like a children's party, consumers will encounter the product without its packaging. So they might not know whether it came from M&S or Aldi. So there's a chance of confusion there. But maybe M&S felt that the attention that had been brought to the dispute made them more comfortable to settle because consumers are now more aware of the different products. And also it did downplay their concerns. If we're comparing all of the lookalike cases, we would say that maybe the gin case is the strongest case because M&S had a registered design for this. And this did strengthen that case. In terms of if we're comparing the Colin the Caterpillar case with the Thatcher case, there were the PR implications and also the existence of other Caterpillar products that kind of weakened M&S's case and forced them to settle as well. So maybe the gin case would be the strongest case, the Colin the Caterpillar case would be the least strong, and then Thatcher would be in the middle. But maybe if M&S had a design registration, their case would have been stronger. But because their product was launched 30 years ago, and registered design protection only lasts for 25 years, it's probable that if they had registered design protection, it would have lapsed. And as Lee was saying earlier, registered design protection needs to be or at least to be filed in the first year of launch.
Yeah.
So they would have had to file it when they were within a year of them launching. So yeah, in terms of comparing the cases, it would probably be the Jane case first, then the Thatcher case second, and Colin Caterpillar third.
Just think maybe M&S waited too long. Like, I'm old, but I can remember 20 years ago, tons of Caterpillars got even worse. And like Melissa said, why did they pick on Aldi? I think it's because Aldi were starting to take market share, whereas not saying Morrison's or Asda weren't, but they'd let them do it for 20 years. And I think people just got used to lots of, like Melissa said, lots of Caterpillar cakes, and they all had to start with a C. Then apart was it Wiggle, doesn't?
Yeah, there's a Wiggle. Slide with them all.
Yeah.
Yeah, they usually go for C names.
I think that also shows to be really aggressive at the start and maybe carve out your little niche. But it's probably, I don't know if M&S, when it first launched, how popular it was. Maybe they just didn't think it was as popular it became. So they just waited. I think they just waited too long. And the PR thing just hit them hard. I just think, I'm going to say Aldi got the higher ground in the PR battle, didn't they? M&S were like silent. They just didn't react at all. So
if you're too close in design and trademarks, that's important. But all of you have mentioned about confusion.
Yeah.
And historically, Aldi never had any of the brands in store.
Yeah.
So again, how could you be confused?
that's their argument. We don't sell their stuff.
Yeah.
So you go into an Aldi and you don't expect to see, you're never seeing it side by side.
But recently, whatever reason, they now actually have some brand in there.
Yeah.
So they're arguably taking a little bit more of a risk. Having them compare and contrast. I guess they're doing pricing comparisons. I don't know, so you can see the difference in pricing maybe.
Yeah. But
it makes it more open to actually, well, now you can see that there's similarity and arguably there is a chance for confusion as well.
The other point to make, you need to be very careful what your legal and branding teams are saying if you're in a supermarket. As there came a cropper, because this can be disclosed to the court, you have a solicitor and a trademark attorney has a duty to disclosure, as you know. You have a duty to court to disclose everything, even if it's detrimental to your case. As with the Specsavers one, I don't know if you can remember that. Their business team, branding team said internally, if legal aren't jumping up and down about this, we aren't close enough. And also there's another case, Tesco isn't there on Clubcard. The branding agency, there was lots of emails between the branding agency and Tesco about, I think the branding agency actually said, you've gone a bit too close. Was it Lidl? Yeah, that was where Lidl sued Tesco and won. And the branding agency said, this is a bit close. What I would say is use the telephone.
Yeah.
Don't stick it on email correspondence. Because whatever happens, the attorney to client is privileged. But if you've got internal emails flying about with people just randomly saying things, just be there, because a judge will read that and sometimes they just think that's too close. So
it certainly makes me as somebody that advises clients, there's a lot of jumping up and down, a lot of jumping up and down, because sometimes you maybe just put around it and you think, no, just within and.
Yeah.
Then often say, oh, we'll take the risk.
Yeah. But Aldi and Lidl, that is part of their business, so yeah.
When looking at these, it's really difficult, I feel trying to find really lovely. To get hold of like actual documentation, to representing what's been registered, what's been protected. Where on earth do you have to go to representation if you were the lawyer representing that brand, whatever? Because if you go to the open source stuff, the RPO section, it's like nothing. That's one part. The other thing is absolutely shocking, just how loose as a goose most of it is. No wonder you get challenged, no wonder it's run. And thirdly, I guess, it's sort of that point about Aldi having only their own stuff in the store, only their own brand stuff. And I think that they've, if only Sylvia would have done it, like I said, this is what I'm trying to say, maybe. For years and years, they've been doing this. Is there a, and it's kind of coming to very long, I've said, by doing this, what they're doing is moving consumers' expectations about what that protection is and what to expect, so that you can no longer then go into the court and say, why is there a confusion? Because they've made that, they're making the markets that go along. I guess
You're right. People go into a supermarket and they expect lookalikes.
Yeah.
It's been going on for 30 years, and the British brands, people have been jumping up and down saying the law isn't good enough. I personally think the law is probably good enough. There is a lawyer on LinkedIn, I'll say it, the app for M&S, constantly pumping stuff up about LinkedIn, about Lidl and Aldi and lookalikes. But you're right, the public have maybe been educated. The other thing is the public have been educated that from a marketing perspective, there's certain colours used on certain products. So if you choose a yellow for a lemon, you can't use that as like your proprietary thing. And it's everywhere, all in all the food sectors. There's a certain look, certain, I don't know, even like financial services, I think blue tends to be used for financial services. Yeah.
And we have what we call our red wall soups.
Yeah.
Which is a red can with the keystone, that's what we called it. Unfortunately, quite a lot of our marketers call it the gravestone. With the keystone on it. And Aldi, when they launched their own brand soups, launched the red can with a black thing on the front with the details in it. Which our internal lawyer said it wasn't close enough. But you know, that's 15 years since I was there, and that sort of thing was going on. And now Heinz supplying to Aldi. So the Heinz red wall soups will be beside the Aldi own brand ones. And I think like Pete says, that's when confusion is going to happen, because you actually have to concentrate on what you're buying to pick up the one that you want. Price will differentiate, but you know, if you're just doing that, what we say, take 2 seconds to do what you're buying up and down. In that 2 seconds, it's very easy to pick up the wrong one.
Judges say we're not here to protect morons in a hurry. But but you think of Cadbury's purple, they do now have a trademark registration for the purple, a certain tone for their chocolate. It went on for 20 years, arguing what they could or could not do, and Nestle were having a go at them and things like this, but they got there in the end.
Heinz will be
yeah.
But I'm telling them there is a specifically designed pattern for.
Yes, it makes people a little bit more circumspect when they're thinking about registering and what they need to register, and that's a really good thing, because
Awesome. Marketing need to, we get the trademark registration for 3D or whatever color, but marketing need to educate the public. This is a brand. This, every time you see purple, it's Cadbury's. They need, it should go together, marketing and law. So it doesn't always happen. So I've advised on both sides. I know I don't care where the money comes from. So But it's just, yeah, and sometimes you just have to go close to the wind and you might expect to. I think M&S have got much more aggressive now, haven't they? So that's that. Okay.
Thank you very much. And we're looking from you, Gavin, before we finish.
No, I agree with everything you said.
Did they taste the cake? They drank
I don't think they ever
it.
tasted the cake. They definitely drank the cider because it was in the press saying the judge had a taste test the first day. So I think they were accepted. There was similar quality, wasn't it? So that was Lidl's argument. We just made something the same quality but a different brand.
About the, Poundland did a Toblerone, which was called
They were stopped.
Twin Peaks or something.
Yeah. They were stopped. Yeah. Because Toblerone do have a shake trademark registration, and to me, if you ask me what is the iconic shake trademarks, one is Toblerone, the other one is Coca-Cola. You immediately see that. Viennetta, getting old now. Viennetta tried to register the shape of the Viennetta, but the judge, the registry said you never saw it outside. When you bought it, it was always in a box, so it was just a box. But I think a Viennetta cake's got a distinctive shape. But I'm sorry, I'm going to stop talking now. Dawn knows I like talking about trademarks. So Melissa was going on about confusion. So she talked about post-sale confusion. That's when you walk down the street and you see it and you might think it's that, and that's the cake. You have pre-sale confusion when you're promoting it, and then you have some confusion at the point of sale on like point of sale stuff. But post-sale confusion is coming much more and more into things, isn't it? So that's that. Okay, great. Thank you. Yeah, great.
So, we'll introduce ourselves when we got here. Tony, you weren't here.
Yeah, no, apologies, it's been a fairly busy week. So I'm Tony Allen, I'm Chief Executive of the AHX Certification Scheme. We test the ID and AHX system work. We're hosting this event this week, on behalf of working with United Nations, on the project that I've been involved in. So I'm just going to give you 5 minutes, because I'm about to go back into an international meeting on the other side of the building, to progress this further. Basically, the project is global standards for age assurance, age verification, age estimation, age inference, and the 3 different types of approaches to how you do age assurance, developing processes for a framework for that, so that you can be able to say, the regulator would be able to say this is what you're required to do if it's an age restricted product. Approaches to measurement and analysis, so that you'll be able to compare different types of age assurance with each other. So you might have one that's doing age estimation, one that's doing age verification, one that's doing a bank check, whatever process is. And then how the technical architecture might sit behind all those. They all work interoperably with each other in a global sense. This week is a part of the standards development process. We have the International Standards Organization in the rooms on the other side here that are currently meeting. I'm going to go back into there at 11:30 to present on the latest decisions. There's been workshops going on here through the week, discussion. We've had the National Institute of Science and Technology from the US publish their results of their benchmarking of people like Yoti, and others for their age estimation. And there is there's been a lot of things around all of that. The theme for today is a tech showcase. So today, the other people that are here are doing basically 12 companies being in a competition to be able to showcase what their products were, and the 12 that won that competition are here, and they're doing presentations in the main theatre. After the meeting, feel free to stay. You're very welcome to go and visit any of those sessions and participate in them. And then the ISO meeting on the other side, and then there's various panels going on in work, including panels about vaping, panels about gambling advertising, panel about gambling, a panel about advertising and role of advertising, a panel about inward investments. There's various things that might be of interest to different people, all around the age restrictions, but might be of interest to people. If you are here this evening, there is an evening event on this evening at Manchester Urban Play. You will need a ticket if you want to participate in the activities, but you won't need a ticket if you just want to come and watch. You get the tickets from just they're free. They're funded by Meta, so you can have your morals about whether you want to on a different day. But there we go from the reception desk there. So I just came here to welcome you. Thanks for coming, BMG. Obviously, it's nice to get out and about to different places. And if you've got any queries or questions, feel free to grab me at some point during the day. Or if you want to participate in any of the sessions, you're very, very welcome.
Thank you. Thanks for inviting us, Tony. For me, it's really nice to get the girls and be to work with in London. Thank you for inviting us. Thanks for it's great. Thank you for the really good event. Thank you.
Thank you. Enjoy the rest of your meeting. Sorry, I've got to shoot off, but I've got to go and do some international diplomacy. Those of you know me, although that's my absolute forte.
Yeah.
Just to say about the location, I actually used to live on this exact street. Yeah, when I started in Manchester and then started renting, I lived on Lever Street, so I got to pass my old house from more than 10 years ago.
Always nice.
Yeah. Overlooks Piccadilly Gardens with the water. It's lovely.
Yeah.
Bedford's stupid. It sounds like pigs, doesn't it?
The one below.
Oh, yeah.
I just said 10 years ago, think about it, I'm 35, so like 15 and more years ago.
That's everything's 10 years ago, don't we?
Yeah.
Yeah.
Do you know where it will be?
Yeah, he was on a folder before.
Oh, yeah.
Go in and, yeah, go back forward. I think I folder with them all. Yeah,
There you go.
There we are. Okay. Thank you.
Slow takes a while to crank out.
Gosh, it is slow, isn't it?
He was complaining.
We're just sort
I
of-
proposed to do there.
This is the temptation to click again, and I probably just make things worse, won't I? Oh, hang on.
City, a little bit.
Well, we need, should we have an AGM and a conference? Anyone can know. There's a pub used to go to the mouse. Is it still there? I don't know. That's ages ago.
I worked with them. Years.
So Frankenstein's conference is at Dalbury's.
Yeah.
The stuff on the calls and.
Well, the calls rent, I don't know how big if you want it. The calls restaurant's really nice, it's still there, but they're moving all along the calls and there's pubs around behind.
What is it?
It's slightly weird, but it's a nice area, there will be pubs then, but the calls restaurant is really nice. That's probably nice, it's better, it's like a bar. But along that road, along the Paul road, just Paul. Or you can come up, there's a whole series of bars, come up from the Falls under like a railway bridge, that's a bit of a part of it. Maybe you want to make it.
Can anybody see where you can? Anybody see where you can start this from? How I can start this?
So bottom right. Got someone.
I think this is blocking it, to be fair.
So the last symbol on the bottom toolbar beside the
It's like a-
slider.
So I always do this way. Oh, down here, yeah. Sorry. It's loading.
Is it loading?
No, you have to wait.
Thank you.
A nice bar opposite that pool, so I can try and find it, and then. Bar from like that. I know that might be really nice. I'll try and find it.
Yeah, you tend to be standing up chatting rather than sitting there.
I would say that, I mean, I'll find it.
Yeah.
It's literally, I've done that before, it's still around, that's fine.
Right, okay, thank you very much, Amanda and Wendy, for inviting me to come and talk to the Business Members Group. I live very close by Manchester, so it's very, very convenient for me. I am the coordinator for Trading Standards Northwest. I've worked in trading standards for about 17 years now, which may come as a shock to some people who may remember a long time ago when I first started. But I'm not a trading standards officer. I did the opposite to most of you in the room. I worked in the private sector. I was involved in sales and marketing, and I was commercial director of a business. Then I took a career break and then went into trading standards, where I have used all of my business skills in order to try and coordinate the activities across the Northwest. At the same time, as part of that, I also joined the year that age of sale changed last time for tobacco from 16 to 18, and I was very involved in that at the time, and ended up working part-time as part of with another hat on for the Northwest tobacco-free futures, which was part of public health, which is how I got very much involved with the tobacco and vaping world. And then as vaping has become more and more of an issue, I have taken a role as one of the lead officers for vaping. Now, you might think it's really strange that CTSI would have lead officers for a subject such as vaping. We don't have one for every other, we don't have one for alcohol, we don't have one for every other single commodity that we deal with. But actually, the reason that they've got these lead officers is because vaping has taken over as a real issue of concern. And I'll show you a little bit about the intel later, so you'll see just what that means to officers on the ground. Okay, so I'm going to start off, if it's okay, with a little quiz, because everybody knows about vaping, because you can't ever open a newspaper or watch anything online without hearing about vaping. So a little quiz to see what people know. Okay, so 10,000 puff vape is illegal. True or false?
True.
Interesting. If a vape is published on the MHRA portal, so it's got to be notified to the MHRA, you can be confident it's legal. If you're a business and you're looking for a product to stock, if you find a product on the MHRA portal, should you be confident that it's legal?
No.
Yes and no. Okay, interesting. Vapes containing CBD are illegal. Okay. Disposable vapes will be banned from April 2025. You think so? Okay.
Mr. Sunia could last that long.
Well, we will have a look at some of those. I don't know whether to go back over these at the moment. So a 10,000 puff vape is illegal, not necessarily. 10 puffs are not in the legislation. So it might be illegal because of a CPR's claim, you know, it's saying something that it isn't, but there's no legislation on puffs. So it doesn't actually tell you whether it's legal or illegal. And obviously if it's got no nicotine and it's 0% nicotine, then you can have as many puffs as you like. And puffs are not in the legislation. So we use it as an indicator that something might be oversized, because the maximum amount of liquid allowed in a disposable vape, for example, is 2 millimeters.
Although in Scotland, it doesn't have to have nicotine to be caught by the regulations.
Fine. Okay. The regulations across the whole UK would include 0% nicotine under the GPSR, but not necessarily under the tobacco and related products regulations, but they will be core under the tobacco and vapes bill, which is currently going for its second reading next week.
So just to clarify, the number 2 that I've got in my head, 2 mil or 2 milligrams, whatever it might be, is that for the liquid or the amount of nicotine in the liquid?
No, the 2 mil you've got in your head is the amount of liquid you can have in a disposable vape, or the capacity of the tank of a refillable vape. Okay, so
and generally speaking, I hear your point about the 10,000. Generally speaking, I've got the figure of 6,000 plus
600. 600 was the thing, but there's technical improvements all the time. Market's way ahead of us in regulation, and probably seeing up to 1,000 in a legal vape. But as I say, it doesn't really tell you anything because there's no legislation for us. If a vape is published in the MHR report, you can comment it's legal. Businesses say this to us all the time, that when I checked it on the website, and on the government website, .gov.uk, it says, if you check a product, if you want to know if a product's legal, you check it on this website. And it's on there, and it's got a registration, all the rest of it. Like, yes, but MHRA only check notifications for compliance with the tobacco and related products regulations. We trade and standards officers, we have reams of regulations to look at. So you could have a product that sits on the MHRA register, which doesn't comply with classification, labeling and packaging of chemicals, for example. It doesn't comply with food imitation regulations, which is why you see some of these little vapes, which look like sippy cups, which we as trading standards say that's completely unacceptable. But it's got a notification. So from a business point of view, it's incredibly confusing enough for us. How must it be for a poor business trying to decide whether a product is legal to stock or not? Vapes containing CBD are illegal. You said they're not because you've seen them, haven't you, in shops?
Yeah. Well, CBD is not.
Vapes containing nicotine-containing vapes cannot contain CBD. Okay, so if you see a vape that's got nicotine and CBD, tell trading standards it'll be removed from the shelves. That's the plan. 0% nicotine vapes can contain CBD, up to the maximums that are allowed for CBD, which are a little bit grey area. And disposable vapes will be banned from April 2025. And I've got a picture of something that you might think of as a disposable vape, and I'm just going to show you, and that's the plan. You know, government have announced they will be banned. Piece of legislation that we're looking at the moment. Let me just have a look. And I'll say, and everybody pushed for this, you know, everybody said, oh, we've got to go ban, it's terrible for the environment, we've got to ban these products. Let me just show you. Be careful what you ask for. This is a single-use disposable vape, which would be legal from April 2025. And this is a rechargeable, refillable vape, which is compliant with the regulations. Now, I don't know about you, but I don't think there's much difference between those products in appearance. This costs pennies more than this. So I think your average member of the public who's used to buying this, when they buy this, will chuck it away in this, as they're doing at the moment. I'm not sure that's going to improve the environment, but everybody pushed for it, everybody whinged for it. That's what they've got. What you'll have are these littering the environment, unless you can persuade the public that's their responsibility to recharge them, refill them, and reuse them. If you can't, which is highly possible, guess who will be blamed for that? I suspect it's going to be trading standards. Why aren't trading standards doing the job? We're already blamed for everything about vapes, so why are we not going to get blamed for the next lot, which is when these products are littering the environment? Hey, that's where we are. And this brings me to my favorite meme of the moment, is that the media absolutely love scare stories about vaping. And whenever you try to present the balanced view of the evidence around vaping, they will not listen. All they want to talk about is, my God, all the children in Bolton, for example, have collapsed and have been sent to hospital. Is it true that all children in Bolton have been to hospital, and there's 2 children from one school who have been sent to hospital? But the media don't like that. They love, love, love. You will have seen stories such as this about the amount of children dying from vaping, and actually no discussion on vaping. can ever take place without setting it in the context of public health. Because everybody says, oh, well, they said that about, they can't, you know, they say that vaping is safe for smokers looking to quit. They said that about tobacco back in the day. Nobody noticed that tobacco was killing people until last century, you know, and people were smoking tobacco all the time. And then suddenly they realized that everybody's getting cancer and heart problems, etc., etc. So it's the same thing. Well, it's not the same thing. And the reason it's not the same thing is because there is so much eyes on vaping. It has not been introduced without an involvement of the scientists. We have some of the top academics in the whole world looking at vaping all the time. They are reviewing the evidence. There are more trials, clinical trials, scientific trials on vaping than on anything else. And in their view, for the 6th time in 2022, when the last report was published, they are saying vaping is a fraction of the risk of smoking, a fraction. Somewhere around here, they said 95%, but they dropped that 95%, and now they're just saying a fraction. It might still be 95% safer, but they decided not to put a number on it. So there's all of that evidence saying that vaping for smokers looking to quit carries a fraction of the risk. So people say, well, you can say that now, but you don't know what's going to happen in years. You don't know what's going to happen. Well, what they do know is they can measure biomarkers of toxicants, okay, which basically they'll have a look at all of the things that tell them. So if you're a smoker, if somebody starts smoking, they very rarely get ill straight away, very rarely. But you can tell from a very early on that they're going to be potentially ill because of the changes in the blood, the changes to the body that smoking causes. So they can look at the same things and say, well, actually, the changes aren't as strong there, or they're different. And what they can say is that the biomarkers are significantly lower among vapers and smokers, but they potentially higher in vapers than non-smokers, which is why the chief medical officer from all 4 nations say, if you smoke, switch to vaping. If you don't smoke, don't vape. It's a really clear message, but we were talking about it before. It's a nuance. It's something that people seem to have problems understanding. There are mixed evidence about potential harm, but there's no major cause of concern about vaping harm to health. So although if you are walking along, you don't smoke, don't start vaping. You know, there's no need to start vaping. You don't need it in the same way that a smoker does. But if you are a smoker, still switch to vaping. And that's the issue, I think, in this country, is that we've got this huge academic wealth of knowledge about why vaping is much better than smoking. But we've also got lots of people going, oh my God, you know, we can't have vaping. What if it's dangerous? What if it's got the same issues as smoking? And this is where the problems are. But the basic conclusions and implications, okay? Vaping poses a small risk of fractions, but a small fraction of the risk, sorry. It doesn't mean it's risk-free. Don't start smoking. Don't start vaping if you don't smoke. So it's very clear that it's an important product from a health point of view, from a public health point of view, and I never ever talk about vaping without mentioning that, because it is really, really important. And in terms of the market, it's a really good market. So it's a really important market to this country. There are many people in the convenience sector who say that vaping has saved their business, because people who sell cigarettes and tobacco, obviously that, you know, sales are going down as smoking prevalence drops. The retailers make peanuts from legitimate tobacco. I'm talking about, not illegitimate tobacco, it's a different story, but they make peanuts. It's very, very small amount. The manufacturers, on the other hand, make eye-watering profits, but let's move on from them. But the retailers make peanuts. Vapes has actually brought profits to convenience stores that they didn't have before. And you know, what is the size of the market? And looking at it, it's 2.9 billion. That might mean more to you than me, so I put it in context. So for comparison, tobacco, which is a small market, as we know, smoking prevalence going down. You're still talking nearly 15 billion sales in the UK. You know, that's how big it is. But toilet roll, which everybody needs, you know, at the end of the day, it's way lower than vape. So you can see what an important product it is for the UK economy, for what we're doing. So, you know, what we for our economy, it is a really important product.
I mean, we need to lead officer for toilet roll.
No, definitely don't need a lead officer for toilet. I can volunteer with you. Yeah. Yes, I'm sure.
Have you got any sense, Kate, of the size of that market if under 18s were buying it?
No, we don't have a knowledge of that at all. No. So we have no indication of how much is being bought by young people, how much is being bought by, and also how much of it is legitimate sales in terms of legal vapes and non-legal vapes. CTSI, we've estimated about a third of the market is made up of illegal products. I've heard people say it's much higher, and people say lower. So it's a difficult one to estimate. So the role for trade and standards in e-cigarette enforcement. So we've got a vast role, as I'm sure you all know. We are responsible for enforcement of tobacco-related products regulations, enforcement of the nicotine inhaling products age of sale and proxy purchase regulations, some aspects of the CLP regulation, obviously for Trademarks Act. When the products are counterfeits of registered trademarks, I should change that slide actually to add in the passing off stuff, shouldn't I? Which we've discussed, and obviously other issues such as weights and measures, consumer protection from unfair trading regulations when a product gives the impression it's legally available to be sold when it's not.
And of course, we do separate Scottish primary legislation around tobacco vape sales.
Yes. Yes, in terms of is the prohibition on a child buying?
It's in the Primary Medical Services Act 2010.
Is it also for vapes as well as tobacco?
No,
just tobacco. Okay. So yeah, so we've got a very wide role, and you know, generally, I talk to a lot of people about, and they say, well, why aren't you doing anything? We are doing the things, but we have got some issues and challenges, and I'll come on to those. So the first issue, legislation is very complex. In some areas, it's quite straightforward. So you will know, because I've already put the red crosses on there, because I took this from something else, that is an acceptable health warning, and that isn't, and that isn't. But you're probably looking at those going, I can't really see the difference. Can't really see the difference between those, and what's the problem with that?
The word warning and a full stop with 2 nicotines, I guess.
Exactly, exactly.
Small, isn't it?
As a general rule, if that was the only thing that was wrong, you're probably not going to take any action, are you? But these are red flags for us. So if we see a product with this on particularly, because that's a real help to us, they actually, if they haven't read the legislation, so they don't know that they can't put warning on, maybe they haven't read the legislation and they put too much in and they haven't registered and all the other things that we need to look for. So it's a bit of a red flag. So it is complex. There's lots of loopholes. The current tobacco and vapes bill, which is out at the moment, hopefully will address some of the loopholes. But for example, in terms of underage sales, it is illegal to sell a vape to an under 18, but it is not illegal to give a nicotine-containing vape to an under 18. I'm sorry, when I'm talking about vapes, I'm generally talking about nicotine-containing. So it's not illegal to give. So what we have had is an issue is that quite legally, whether a responsible business would do this or not, it's a different thing, but quite legally a business could sell a 0% nicotine, what we call a short fill, to a child and give them the nicotine shot, and they could mix it, child could mix it up, they would have a nicotine containing liquid then. So that obviously isn't a good idea because there was no supply, there was no provision in the underage sales. We've got new regulations coming along, and sometimes those haven't really been thought through properly. They're just knee-jerk reactions. So the one I showed you before with the what's been banned and what's not been banned with the single-use vape ban, but people think it means, oh, there'll be none of those around anymore, and that's not actually true. And there's lots of new regulations coming. Powers some of the issues around the different bits of legislation are where our powers come from and what powers we have. So on the disposable vapes ban, for example, it's going to be environmental legislation, and we have very, very poor powers under the EPA. They put powers in, so they've put powers in, they can go in and we can say to a shop, no, you mustn't do that, and we can take a sample of the product. Now, that might work for plastic plates, forks, cotton buds, but for a market that's already so dominated by illegal supply, we need our powers to go in. We need our powers of entry. We need our powers to break into concealments. We need our powers of seizure. We need powers of forfeiture from the CPA. We need all of the things that we normally rely on for this area. Whose responsibility? Now, mostly it's for trading standards, but sometimes other people have to step in and it's their responsibility. And some of the things, it's difficult to know, whose responsibility it is. And as a general, at the moment, I was saying to somebody, there's a weekly call of all the different agencies involved in vaping at the moment, because there's so much legislation changes that are going on. And it seems to me that other government departments are able to just say, no, we don't want to do that. Or HMRC says, no, we don't want that. And Border Force will say, no, we don't want to do that. And we're trading standards thinking, we just get left with doing everything. We don't get the option to say, I don't think that's a good idea. There's a perception of the size of the issue. Everybody thinks it's a humongous issue, that all children are vaping, that, it's all of the things, and they're all vaping because of the flavors, or they're all vaping because, I don't know, they're given them or whatever. They're all vaping because they contain THC. Well, obviously that's an illegal drug issue. It's not a trading standards issue. That's a police issue. If you've got illegal drugs in anything, don't speak to trading standards, speak to the police. And everybody's interested, which is good in some ways, because it does raise the profile of trading standards. And we have been promised a share of quite significant funding for enforcement. I haven't yet seen the detail of that, so it'd be nice to know what that was. But yes, everybody's interested, which is an issue, a positive and negative one. So I mentioned I would tell you about some of the issues we've got. Oh, I know, I've done. So this just gives you, the IDB is the Trading Standards Intelligence Database, which you are probably all aware of. And these are the intelligence logs around age-restricted sales for 2023. And that blue blob are vapes. So there's alcohol in there, tobacco, knives, fireworks, everything, and lots of other things that we would get reports on, intel reports that we would act on. But you can see just from that how it's just such a significant part of our work at the moment. In England, and I would very strongly say that in England, we were given funding about 12 months ago, or we were offered funding about 12 months ago, under a project which we call Operation Joseph. We maybe should be thinking of the cakes, we call them Operation Colin, but all of our operations at the moment around the tobacco and vapes world are named after cats. So Joseph is the cat belonging to the Director of National Trading Standards, so which is why it's called Operation Joseph, but it's also the name of my middle son. So my older son and my younger son keep saying, why haven't we got an operation named after a You're not named after a cat. So Operation Joseph gave funding to Trading Standards, not to do any work that we're doing anyway. So we are intelligence led, we do respond to intelligence, so we are doing a lot of work on this, but to try and do some of the stuff which is not possible to do, which doesn't happen unless we have funding. So we're gathering a lot of data. We're trying to identify gaps in the enforcement, which is part of the thing that are coming from the Tobacco and Vapes Bill. From those gaps we've identifying where the main the pinch points are, and pinch point is clearly at the borders, because no The disposable vapes are the most common among children. Disposable vapes are about 50-50 in the market, but the most common among children, which is people's main concern. Obviously, main concern from the environment point of view, they all come from overseas. They're not made here. A lot of the liquids are made here, but the actual disposable vapes, which come in completely made, they're coming in from overseas. So the pinch point is the border. If we can get to grips with the borders, we will help inland.
And who enforces this at the border? Because I used to work at, I used to lead one of the imports teams. And I'm very quickly in my head trying to work out from the list of legislation you gave, which ones we have powers for at the border. Things like the General Work Safety Directive. But most of them you didn't have. Has that changed?
No. But no, but that's the issue we've got, is that we've got legal opinion on whether we can use our powers in certain situations. There are probably some officers who are using the Ways and Means Act, to be honest, but we have got legal opinion about whether we can use our TRPR powers, for example, Consumer Rights Act powers under the TRPRs at the border, but it isn't great. It really isn't great, the situation, and that's why that pinch point at the border isn't brilliant. But as I say, the legal opinion does help, obviously, but it isn't necessarily the be all and end all. But to be honest, people bringing in illegal vapes are criminals. You know, they're not legitimate people. They're not Aldi who are just trying to get one over on Marks and Spencer's. They are organised crime. Are they likely to take us to court? You know, bring it on. Bring it on. Do it. Let's see what happens.
Whose legal opinion is that?
No. TS have obtained it. Yeah. A barrister's opinion. Yeah.
Who obtained it?
A Trade and Standards Supports Authority. Yeah. Okay, so under Operation Joseph, as I say, one of the things we're doing is gathering. So this gives you an idea of some of the work we've been doing. And again, I do spend a lot of time talking to businesses who say trading standards aren't doing anything. And actually we're doing a lot, considering how small our resources are and how pressured we are, we're doing a huge amount. So in England, the minimum 1,200 premises, I know you do a huge amount of test purchasing in Scotland, so this probably looks small to you, but
well, it's not, it's huge, it's bigger relative to against about 10% premises, but yeah, we had a program tobacco 2011 and 2017 for vapes, 11 for tobacco, funded by Scottish Government, which is reasonably effective.
Yeah, so this is not funded, these are all intelligence-led test purchases. We have had some funding for doing market surveillance test purchasing online, because obviously that's not something you could do by local authorities, particularly. So we've selected a couple of local authorities to do that for the country. But you can see the failure rates are around 25%, which is higher than we would expect with alcohol or tobacco, but it's not unbelievably out of range. You know, it's still too high, but it is. You know, this is all intelligence led, so these premises have been reported for selling to children. When we send in our person with no makeup, with, you know, looking young, probably would pass all of the tech, would fail the tech, you know, if the tech was used in those particular stores. And in terms of seizures, these are inland seizures. This is so far to the end of December, we'd seized 890,000 illegal vapes inland. The ports issue is slightly different. We're collecting the data differently. We haven't got that available yet. Okay. So the future regulatory framework in the UK, I mentioned, what's definite. So we know that closing the loophole, which allows nicotine containing vapes to be given free of charge to anyone of any age, that will be closed. We know there will be fixed penalty notice for underage sales of vapes and tobacco. It's not going to be the answer to everything, but it's just an extra tool. We all know in this room how hard it is to get to court at the moment, you know, and we had how many 500 failed test purchases, you know, trying to get 500 cases into court when the delays are so long. It's not going to happen. So a lot of the time people are giving warnings rather than prosecuting. So having something else in the toolkit will help. The disposable vape ban, which I mentioned, will it work? Will it make a difference? I'm not sure that it will. And we're also consulting at the moment on a vape excise tax, which I had pushed for and thought it was a good idea, because it would get HMRC boots on the ground to try and enforce against illegal products. However, HMRC have pointed out to me that if somebody pays the excise duty, then their product is then okay. I think, well, what if it's illegal under our legislation? And they said, you need to talk about that. So there might be a little bit of discussion on that one.
Just a point on the fixed penalties. So in Scotland, fixed penalties have been around since 2010.
Yeah.
And at a higher level. So it's £200 as opposed to £100 opposed for England, which doesn't seem very much of a deterrent. And then in Scotland, it's on an escalator, so on fences, so it's 200, 400, 600, 800.
Yeah, this is only in addition to and to be honest, I suspect we'd never use it against a business, but against a person in a shop, it could be, you know, £100 is quite a significant amount for a shop assistant, and we can choose who we use it against. So I think it will be an addition rather than a substitute. And at the moment, a lot of cases are just getting a warning. So I think even something is better than nothing. So what's on the table? So at the moment, the Tobacco and Vapes Bill, which I mentioned, has got a second reading next week, and then we'll go into committee stage, includes enabling regulations to restrict flavours, packaging and displays. It won't actually do it themselves. The specific regulations will then need to be consulted on and discussed and agreed. And it will include 0% nicotine vapes, which we think it ought to be, because we think that's a bit of a loophole as well. And other nicotine products such as pouches. A nicotine pouch you may never have seen, but they're now, I'm seeing them in every shop I see vapes. I'm seeing nicotine pouches, the little tins. In the tin is a little pouch which you stick in your mouth, and the nicotine goes into the system. I think they're being strongly promoted to young people as a cool product. Footballers are using them. They call them snus. They're not snus. Snus is banned, as we all know, but they're calling them snus because they like that foreign sounding name. Snus was a tobacco pouch which used to be, and that's not allowed in this country. And there's also discussion about an import ban, which we've asked for. An import ban is possible under the EPA for environmental purposes. So we've asked for an import ban. Everybody's telling us why it'd be really, really tough, but I think it will be something that will make a big difference. And why more regulation? Although I probably don't need to say this to a trade and standards audience, but if I'm speaking to businesses, why more regulation? Why more regulation? Well, why don't we just educate children about not using vapes? Well, I want to show you this about smoking. So in around here, all of this time leading up to the year 2000, people were educating young people about smoking. Okay, if you look here in 1984, you look here in 1986, there isn't a difference in the smoking rate for young people. So they're getting lots of education about this is not a good idea, but there was no real regulatory changes. And then here, from 2000 on, the smoking rate in young people has come way down. And at the same time, all of these laws have been brought in. Tobacco advertising, smoking in public places, age of sailing, police picture warnings, cigarette machines ban on smoking in vehicles, mental ban, all of these things came in. So that's why more regulation will work, and that's why it's needed around vaping. And finally, I will just finish off with my picture of me. This is our job at the moment when it comes to vaping, is we are on a tightrope. And half the time people are going, we're not being tough enough on vaping, and the rest of the time people are saying, no, you're being too tough on vaping. It's such a hard area to try and present a balanced view, but at CTSI we think it's really important that we are the voice of balance. We are trying to ensure there are products out there which will make such a difference, and our public health colleagues are asking us to do this. Obviously in England, local authorities have a statutory responsibility to improve the public health of their communities. Vapes is a way of doing it, But on the other hand, we also have people pushing us going, oh my God, kids are vaping, you know, these are dangerous to the environment, etc. So we've got to try and present that balanced view all the time. And it's not easy, but we will continue to try and do it. Okay, thank you very much.
Ever regret sticking your hand up when the next
So every single day I think, why did I say that? But sometimes you can actually see differences you're making, and sometimes you can actually see that more money is coming into trading standards. And I think, watch this space, because I think far more money will be coming into trading standards, and that's because of vaping. And I know that sounds bizarre, particularly to people, and you're thinking, well, hang on a minute, we're doing food standards, and that's so important. Trying to get engagement in that. You know, metrology officers are always complaining that nobody's interested in metrology. Especially in the Northwest, people are always complaining about that. But to be honest, it's not something that's going to get them money, and we are going to get money, and we're going to get money for people. And when you're going to say to me, there aren't any people out there, but I think we're going to get money for new people. Now, some of you might remember, trading standards people tell me there used to be an offer of a buy one, get one free. Does anybody remember that? Do you remember that?
How I was paid.
Well, I think we're going to have something similar, but maybe not a buy one, maybe have them all free. So just keep watching the space, because I think we've got this potential opportunity to get new blood into our profession through vaping, you know, which is got to be. Sorry?
I'm getting the wrong end of the stick. No, so way back when they did the government even first was going to
So you could have more people coming in generally. It's probably like anything, it's cyclical, isn't it? So there's not enough trading standards officers. So government, oh my God, we need trading standards officers. So let's help fund more trading standards officers. We've got enough trading standards officers. And then they think, oh, we don't need to fund that anymore. And then they forget that actually people get older and maybe want to retire. And I think CTSI's figures on the number of the age of the profession is unbelievable, isn't it? The profile. So we're about to fall off a cliff. So yeah, it's really important.
It go round and round.
Yeah.
Funding, etc. Inspiring thing.
Are there still the trademark lookalike issue with vaping?
Yes.
Well,
Yeah.
No match for vaping.
Yeah, we're both must do, don't we? Got quite a big client produced outside of the UK.
So there's issues. I think there's issues for products which are purporting to be legal products in the same way, typical counterfeits. But one of the things that Gavin's certainly been challenged with lots are passing off.
Yeah.
So, and also giving the impression, and I was really interested in what you're saying about the reputation. So the reputation of a you know, a product like Skittles, you know, they absolutely do not want their product name or the impression or the picture on a vape. You know, or cookies or any of these products which appeal to children. It's a very complex area as well. There are so many illegal vapes out there that quite often we don't need to go down and have complex bits of legislation, because they're just easily, you know, they're generally illegal. But I think as it changes, we might see that more and more, that we can't just take them off the shelves. People will fight back. Sorry.
Sorry. Bringing on to an environmental thing.
Yes. Yes.
I was just interested in the environmental protection piece around that as well.
Yes.
So is that Environmental Protection Act 2021?
No, it's the Environmental Protection Act 1990 is an enabling piece of legislation. Now, Section 140 allows ministers to bring in regulations if something is injurious to the environment or injurious to human or animal health. Okay, and then they can put in a ban on sale or supply under Section 140, which is that's the powers they're using to bring in the statutory instrument. And there's a different statutory instrument in England, in Scotland, in Wales, and Northern Ireland, but they will all be combined together to get the World Trade Organization to have overall approval. But that's the overarching bit of legislation is the Environmental Protection Act 1990.
I'm quite surprised in a way that, and I don't know if that would be feasible, better heads than me understand it better. But no one's sort of tried to bring an action against the government not instituting something to control that.
But
Wildlife protection really.
Yeah, they are. So the government have laid this statutory instrument. DEFRA have laid the statutory instrument. As far as DEFRA are concerned, though, they're only focusing on the and there are there's loads of other regulations around vapes, around environmental regulations. So so the WEEE regulations, obviously, all retailers now, if you sell vapes, you have to do take back. You have to offer take back. There used to be sort of a way out of that, where you could sort of join up to a scheme and you could say, oh no, take them to the local authority because we pay into this scheme and the local authority can get money from that. They have to have that provision now. Fortunately, not enforced by us, enforced by OPSS, but so anything that we can say, oh no, it's not us, like drugs, we say, oh no, that goes to the police, or no, it's OPSS. It's quite nice, but no, well that's
Oh, I am.
I've seen the bonds, but I'm not seeing any actually.
They like TK Maxx.
oh, do they?
That's what they all are. Run to get TK Maxx.
I think to be honest, I think that one of the issues is I think OPSS do think a lot of it can be done by working with businesses to improve compliance, which obviously you can do with a company like TK Maxx, but it's dodgy Dave on the corner who's going to be the issue. But
That confrontation stuff, I've never seen.
I can't. Well, as I say, I'm not 100. I mean, they've got great powers and huge fines they can impose.
If you look at their annual enforcement report, which is my bedtime reading, the most enforcement they do almost year on year for the last however long they did 5-6 years is the timber regulations that they enforce. They love a bit of timber.
Interesting. So we're now moving on to this.
Actually, have a real impact on safety, which is in their name. Timber building.
Thank you.
No problem. I'm sorry for going on longer than I was having. I tell you what, shall I start putting this up now? And then,
Oh, sorry, no.
oh, you've changed it. Okay, so it's a different one on here. You might want to start putting it on now. Just. No, I don't. But most of my time, you have to do the dividing up as over. It's really hard. No, I don't want to do it. I'm glad it's not.
You're really interested how it's just from out of nowhere. I've got a few baby friends. I'm not, yeah, gonna do it myself. But it's really just taken just like everyone our age. And I've got friends that are teachers and all the kids work in the toilet now and could do it.
They see the partnership there. And it's and what's going to happen.
Well, smoking is on it.
What's that? But yeah, they're not there.
Now, reason more interesting. Yeah. I should be required to say, yes, I recommend you. Maybe that opportunity is.
Yeah. More than.
Yeah.
Well, it describes exactly what's going on, doesn't it? It's on your way to the supermarket.
Well, they certainly spoke about that, so the problem is that was in the flood barriers and then that was last about. Laura and I were going ahead, just not doing that.
Well, thank you.
Thank you very much. Thank you very much.
Yeah. Hi. Good and back
Lauren's.
So you intended to renew
Oh, well. Great, that's not.
Yeah, thank you.
Yeah.
No, I didn't.
No, I have to share something about what's developed also.
Okay.
Which I think probably.
It's looking like the way, isn't it?
Definitely, every day, yeah.
No, I know.
Trying to listen as well. You just like mostly thinking that maybe like I wasn't thinking like that. Well, it's nice I don't like I couldn't take more away from it. Shit, but it's only like that. I suppose JP was that. And that's just not yeah, it was. Yes.
And how it's.
Yes.
He's allowed to make it.
Yes. Yes.
It's actually the seal.
Yeah, yeah, that's what I talked to, so yeah, so.
So it's about, say, reasonable.
Yes. There's no really. Yeah. If you possibly, the. Estimate was the, which is. Yeah. Yeah. It used to be.
Come across any CBD label trucks that are using the word cancer in their advertising.
Yeah.
And they can really nice.
Oh, well, yeah, I was just like, it's just because the young lady was speaking in a very soft voice and I had to shut them so I could hear her. Let's see if this will work. Oh no, that's not supposed to happen. Ah! That's the wrong bit come out. Yes. It's not seeing the, is that, well, there it is. It's a bit slow, this thing, isn't it? I'm on the graveyard shift here. They're all out there smelling that lovely food. Whilst people are being distracted, aren't they? Is this a print? Or a click? Looks like it, but I might have to sit down with this one.
One train defence officer would never.
Cool. It's about. Oh lordy, look at that. I can go on my computer if it doesn't play. Plug it. I don't. There it is. Know which ones. To you. For the standard is this.